I received a phone call from a client last week who I represented in the divorce who has sole custody. That individual asked if they could move out of state with the child on the basis that sole custody was in their agreement. And the answer is no. The other spouse, the former spouse, has rights with regard to access, and those have to be taken into account in determining moving forward how we're going to set that up to make sure that the father or the mother who's staying behind is still going to be able to exercise those rights. So first, you have to sit down with the other party, see if you can work out an agreement, an arrangement for transportation and for time periods in which the child is going to be here in New York. If you can't do that, you have to be able to articulate circumstances for the court as to why it is important and in the best interest of the child that you be allowed to relocate, because the courts here are only going to be interested in what's in the best interest of the child. So if you want to leave because you got a better job offer, that might be a factor. If your income's going to increase substantially and you're going to be able to provide more for the child, the court's going to take a look at how it is that the visitation has been working, how access has been arranged, and how that's been exercised by the party who's going to be staying behind. And the court's going to take a look at the overall view of the circumstances for the parties to see if it's practical, given the age, the education of the child, and where the child is as far as schooling is concerned, and determining whether or not you're going to be allowed to relocate with the child.